The model kind of assumes or kind of posits that the trial court judgment is like an option, right? It's like a backup option. It's a safety net, if you
That's right.
will.
Right.
And when they go to appeal, they always have that safety net they can come back
That's right.
through. Is kind of what the model assumes, right? Or
Right.
what the
Right.
model builds on.
Law and economics has been a success, and though part of its success has caused a backlash, and so there's some universities, there's some law schools where it seems that there's a strong antipathy toward law and economics.
Say you file a lawsuit and sadly you lose. Or maybe you win, but you don't win by as much as you think you should. When is it rational to actually appeal that decision? This is the topic we'll be discussing today with our guest, Keith Hylton. Professor Hylton is the William Fairfield Warren Distinguished Professor of Boston University and a professor of law at Boston University School of Law. He joined the BU Law faculty in 1995 after teaching for 6 years and receiving tenure at Northwestern University School of Law. He earned his BA from Harvard University, JD from Harvard Law School, and PhD in economics from MIT. He is a prolific scholar who is widely recognized for his work across a broad spectrum of topics in law and economics, including tort law, antitrust, labor law, intellectual property, civil procedure, and empirical law analysis. He has published 6 books and more than 100 articles in numerous law and economics journals. He is a former president of the American Law and Economics Association, and he is current editor-in-chief of the Review of Law and Economics. And he's got many, many prior roles as chair and director of other legal associations and journals. He grew up in Detroit, Michigan. Today, we're diving into his work on the economics of appeals, where he tackles an important question about modeling private incentives to appeal, which was missing in the academic literature before his publication. Join me in welcoming Professor Hylton. Hi, Professor Hylton. How you doing?
Okay, how are you, Laura?
Good. Thank you for joining me today to discuss your article, The Economics of Appeals. And your co-author, Sanghoon Kim from Hankook University, also co-authored it with you.
Mhm.
I was very fascinated by your article.
Oh, thank you.
So I just think it's just one of these classic, law and econ articles to put out there, just modeling behavior and cost benefit analysis. Do you want to give an overview of what the article is about, or would you like me to do that and we could talk about it?
Yeah, I'll give an
Yeah.
overview, and then if I don't touch on the right things, you can tell me, what I missed. There are many technical details in the article, and so I'm not about to trawl through those technical details, but maybe I'll tell you the story about how we wrote the article.
Yeah?
We were working on an empirical paper that tries to use a new estimation method for for using appellate court data.
Yeah.
And one of the questions that we were trying to model, create a model for this new regression method, and it dawned on us as we talked about it that no one had really seriously modeled the incentive to appeal lower court judgments, because we realized as we were trying to write the econometric model that we had no basic model to go on to use, and that seemed to be surprising to me because as we talked about how we would set the model up, it became clear to me that we didn't have a clue of how to set the
Right.
model up, and there were some basic questions. So we came to the conclusion that we had to look at the incentive to appeal. If you think about that topic, one's reaction might be, "Gosh, isn't that a basic question for someone to be looking at in 2025?" Because the law and economics literature has been around for quite some time. And perhaps the first article on the incentive to litigate, those articles were written back in the 1970s, much of it in a series of papers. So it's been quite a long time that all of that has been out there, very simple
Right.
models looking at the incentive to litigate. And it's sort of surprising that those models have not been extended to looking at the incentive to appeal. And that's what we did, and that's what we tried to do. And so the fundamental model is actually a very simple one, and it's an extension of one that's been out there already. If you look at the paper, it might look at first like it's complicated, but it's actually very simple. And, it's just a bunch of, terms that are floating around that may make the paper look more complicated than it is. So we just tried
We
to,
like to say elegant, not
yes,
simplistic. It's elegant in its simplicity, right?
I'll say that. I'll agree. In high school, I was really more of an art student than anything else. And so elegance actually is a big deal to me when I write a
There you
paper.
go. Beauty, elegance. Yeah, you did it. You
I pay a lot of
achieved it.
attention.
No, yeah,
I pay a lot of
I've got
attention to that question.
you pay a lot of attention to the to the beauty and simplicity and elegance, yeah? From an artistic
From
and
an artistic point of view, yes.
yeah, I love that.
I'll
I
admit
love
that.
that.
I will admit that. We're trying to model in a very straightforward way what motivates someone to appeal, what motivates a plaintiff to appeal from a trial court, what motivates a defendant to appeal from a trial court.
Right,
And a lot of it is sort of similar to the incentive to litigate at the trial court level. Of course, in the trial court level, the only person's incentives you're looking at are the plaintiff's incentives because it's the plaintiff who runs to court and sues.
right,
And the defendant's only question is, do I fight this case or do I just settle right away? But at the
right,
appellate level, both parties have an option to go run to the appellate court. So both parties have, incentive conditions that determine whether they go to court, the appellate court. And so part of the model is determining those incentive conditions. What are the incentive conditions that describe a plaintiff's decision to appeal or a defendant's decision to appeal, or cases where both parties decide to appeal, cross appeals, that is, or cases where neither party decides to appeal. What are the conditions that describe those cases? And we did that. And, there's for a plaintiff to want to appeal, he's got to be sufficiently optimistic about the appellate court outcome. The other question we're asking is settlement because the parties could appeal. One of the parties could decide to appeal, or both parties could decide to appeal, and both parties might decide to settle
right,
instead of appeal. I mean, they could settle at any time. They could settle
right,
before they get into the appellate court, or they could settle the day after they get into the appellate court. And so, what are the conditions that describe that settlement decision at the appellate level? We thought that those were interesting questions to look at, and sort of surprised that no basic model had looked at that before. So we see ourselves as examining really basic questions. What causes people to run into the appellate court? What causes them to stay there instead of settle because, one of the parties could settle to thwart the appeal of the other party.
mhm,
And the same questions come up in the criminal context too, because in the criminal context, you have the same incentives instead of a monetary. In the civil context, it's a monetary judgment that's usually the issue. Though the model that we wrote could easily be changed to consider an equitable remedy instead, an injunction, and
right,
you just assign a dollar value to the injunction.
right, to the value of
The on now
the
that yeah, now the only difference with an injunction is that you might have different valuations placed by the different parties on an injunction, if it's
on what that means to
yes,
be
yes,
stopped
yes,
from
if
doing
it's a
something,
monetary
yeah,
judgment, $100 as $100, to both
right,
sides. But if it's an equitable remedy, shutting down some activity might be worth one thing to the plaintiff and it might be costing a different thing to the defendant. So
right,
that's the only complication that would arise in the model if we took the model and just said, let's apply this model to equitable remedies. There'd be this different valuations from different sides. And, that might be a worthwhile thing for us to do in a paper. Our view in writing this paper was that it's a skeletal framework from which anyone can build. So if someone
right,
else decided, "Oh, I like that model. I wanna see what it implies for equitable remedies," they can do that. They're open, it's fair game for them to do it. They don't have to wait for me to do it. Or if someone looked at the model and said, "Well, let's suppose the parties are risk averse instead of risk neutral."
right,
Uh,
right, right.
anyone could do that. I mean, I could do it myself, or if someone reads the paper and they said, "Oh, I wanna do that," they can go ahead and do it. That's so the model
That's
is
yeah, that's the beauty of the paper. It's like a launching off point for so
right,
many questions and why, this is gonna be such a great podcast because and, there are all those layers to it that you can add on, and what if this happens, and how does that impact. But this when I was reading the paper, this equation, this is when it started to make sense to me on page 57. Just this simple, the a way of expressing the plaintiff's rational appeal condition is basically the probability of success on appeal multiplied by the expected
Award.
award on appeal
Right.
minus the cost to appeal.
Mhm.
That has to be greater than what they already got at trial.
That's right.
And the model kind of assumes or kind of posits that the trial court judgment is like an option, right? It's like a backup option. It's a safety net, if you
That's right.
will.
Right.
And when they go to appeal, they always have that safety net they can come back
That's right.
to. It's kind of what the model assumes, right? Or
Right.
what the
Right.
model builds in.
Yes, I referred to the trial court judgment as an option because it's something that's there, once the plaintiff appeals, but at the moment the appellate court renders its judgment, it disappears. So
Right.
it's an option that the plaintiff can go after to a certain. I mean, I think, in real litigation, many lawyers would probably say, well, it's more complicated than that. So you have to make simplifying assumptions. But the simplest assumption is that trial court judgment is an option that just vanishes the moment the appellate court renders its decision. That's one feature about that term DT that appears in the equation. We refer to as an option because, it's something
Right.
there for now, but it's going to disappear once that trial
Right.
court renders a decision.
Right. Now the other part of your paper that I thought was interesting were these two graphs. I mean, you have more than just two, but the figure 1 as
Right.
compared to figure 3,
Right.
kind of
Right.
these two settings, if you will, where you're modeling essentially on the y-axis the plaintiff's assessment of its
Yes.
probability of winning on
The plaintiff's
appeal, and
optimism. Yes.
and then on the x-axis kind of like the
That's actually the defendant's pessimism level.
yeah.
Yeah.
Oh,
No.
oh, on the y-axis that you're saying that's the defendant's pessimism, right?
On the
It's yeah, you
x-axis,
could frame it
it's the defendant's
right.
pessimism on the x-axis.
Correct. Oh,
Yes.
correct. So this was interesting to me how you can see in this graph that it's a beautiful dynamic between like the party's subjective assessment of their probability on appeal,
Right.
but then there's also this interplay of the magnitude
Yes.
of winning, right? And
Yes.
that's what kind of frames the difference between figures 1 and figures 3.
Right.
Can you kind of like explain that like I'm a
Yeah.
4th grader because I got a
Right.
4th grade son who's going to be listening to this.
Yeah.
Like kind of explain what that
Right.
means and why these two graphs
Yeah.
in figures 1 and figure 3 look different.
Yeah. Well, all we did in these two graphs was consider different ratios of the trial court judgment to the appellate judgment. So in the first one, the trial court judgment is, less than one half of the appellate judgment. And in
Right.
the other one, we flip it and have it. Let's suppose the trial court judgment is greater than one half of the appellate judgment. So,
Right.
so we get different regions. For example, if you look at figure 3, the no appeal
Mhm.
portion is quite large.
Huge, right.
And that means that you've got to have really optimistic plaintiffs to want to appeal. And conversely, defendants who are, I guess, you know, who believe that I'm looking now at the
Oh, yeah.
x-axis right now, defendants who
Mhm.
are, down there in the low p hat A, where it's
Right.
very likely the plaintiff will lose. That is, they're not pessimistic. So what's interesting is that what that figure 3 shows is that in those conditions, you won't have a lot of appeals. And so that means that has implications for the previous literature, because much of the previous literature was about the so-called error correction function in the
Right.
appellate courts, how appellate courts kind of rode over the trial courts and kept them at a leash. But if people are pessimistic,
Right.
then no, the people are pessimistic about what's going to happen at the appellate level, but defendants are pessimistic and plaintiffs are pessimistic, then the appellate courts won't do much in terms of serving as constraining mechanism on trial court.
Mhm.
So
Mhm.
all of this,
Right, like, they could be flat out the trial court could have been flat out wrong, but if it's not worth their while
yeah,
monetarily wise, they're not gonna go forward with
right,
the appeal, so there's
right,
really like, the constraint on the trial court judges is not there if it's not
that's
so far off in
that's
magnitude,
right.
right?
Yeah, and you could, in the worst case scenario, you could imagine a story where the trial, as you just put it, the trial court judgment is flat out wrong, but, the plaintiff thinks, well, the appellate court is also gonna be flat out wrong too.
Right,
So
right, right,
so
right.
why would I appeal this flat out wrong
Right.
decision? Because I'm just gonna meet the same problem once I get it into the appellate court. It
Right.
might be a picture like suppose you have an appellate court that is just deferring to the trial court. It just says, "Oh,
Right.
whatever you said, trial court, that looks good to us." Well, that would be a case where a plaintiff who doesn't get the judgment they wanted would be pretty pessimistic about getting something better at the appellate court level.
Right, right. So based on these 2 charts and your model, it kinda seems to me like from the outside looking in, you couldn't necessarily predict whether there's going to be an appeal or not, because you would need to know the subjective probability assessments of the parties, right?
Yeah,
So it's
that but that's
yeah.
true, but what we also like what we one positive of this model is that, first of all, we could look at different areas of litigation. That's what we do at the end of the paper, look at different areas of litigation, and we ask ourselves, what kind of parameter configurations would be consistent with the results that we're seeing out there that people are reporting, and do these parameter configurations seem plausible? And we make the argument, in short, that yes, in fact, what we're seeing in many of the empirical papers on litigation outcomes are consistent with plausible parameter configurations in the model. And in that sense, we can, we would offer the hypothesis that much of the literature, the empirical literature on appellate outcomes, can be explained by some very simple parameters that we're using in our model. Now, what's
Right.
important about that is that a lot of this empirical literature that I'm referring to, a good part of it makes the argument that, for example, the defendants do relatively well in appellate court because appellate court judges are biased toward defendants. It offers that conjecture, and now the reason for bias isn't set out, but there have been a bunch of theories in the literature, in the law literature, for a long time for why judges might be biased to defendants, and they run all the way to class-based arguments. Well, judges are they're wealthy people too, and so
Right.
and it's wealthy defendants come into court, and the appellate court judges favor them. Well, I think what we're suggesting is, before you resort to those theories, why don't you just take a look at the basic incentives, and you
Right.
probably explain a lot about the data from the appellate courts just using a simple model that looks at incentives, looks at the amounts at stake, cost of litigation.
Right.
Uh,
Yeah, it would be interesting to see this tested empirically, like, from a fresh I guess you looked at empirical data and kind of back reverse engineered it kinda to see how it applied to this model, is that what you're saying?
that's right, that's right.
Yeah.
But the model could
Yeah.
be engineered forward. I mean,
Right.
you could assume certain distributions on costs, on predictions, and then under different assumptions, you can generate data. You can simulate the model and generate data on appellate court outcomes. And if you found, for example, that you could replicate the real data, then that would be a way of saying, well, look, if these parameter configurations are what's generate data through the model that maps that, or that sort of is just the same as what we're observing, then maybe that's telling us that what's happening in the real world is close to what the model says under certain parameter assumptions, or under certain distributional assumptions. That's one use of the model. It's a pretty simple model because you could make up you could put certain distributional assumptions on the beliefs of plaintiffs or defendants. Could be a very simple uniform distribution. You could simulate the model and get different results, and then look at the results you get from the simulated model and compare those simulations to the data that actually exist, and see whether the model seems to be capturing, what we're seeing out there in the real world.
Got it. Now, I'm a lawyer myself. I've been practicing for 14 years and I studied law and economics and I do deals now. So I don't do litigation, but for this episode, I did talk to two litigators. I
Okay.
talked to an appellate litigator at a big law firm and a trial court lawyer that does some appeals. And both of them kind of pointed to a couple of things that I was curious to hear your thoughts on. The
Okay.
first big one was like some of my clients just wanna litigate on principle, right? Litigation is the sport of kings, and even when I was I that's the as the
Yeah.
saying goes, right? When I was at Greenberg Traurig, I was a baby associate. I remember our litigation partner brought me in to do intense case law research on 6 inches of an easement, on Palm Beach, and it was like, "This is a litigation, this is a case?"
Right.
You know?
Right.
So how does that factor in, I guess, to this? And is that just irrational and we could disregard that behavior?
No, it's certainly part of human behavior. I mean, the model assumes, rational people who are risk neutral, but in the real world, not everyone's rational, not everyone's
Yeah,
risk neutral. But let's suppose we say people are rational, but they're not risk neutrals. Well, you can generate a lot of weird behavior just by saying they're not risk neutral,
right,
because once you say they're not risk neutral, you might have people who are extremely risk averse, so they don't want to litigate no matter what because litigation is a gamble. Or you might get people who are risk prone, who are risk lovers. And for those people, they want to litigate because litigation is a gamble. They really want to get out there and litigate. And so you could say, some of the people who are super litigious, that they're like the risk prone people. And no, of course, and then so that's one approach. One approach is say, well, they're rational, but they have strange risk preferences. Another approach you could say is, well, they're not fully rational. Now, of course, the difference between these two isn't great, it seems to me, because saying someone's not rational, but they have risk neutral preferences, or saying that they are rational, but they have strange risk preferences, those could generate the same
I
results.
know, this
Model,
is this is like the age-old debate though, right? Isn't this like the behavioral
Yes.
economists will come in and say, "But we realize that people have bias," and then the economics people say, "Well, we'll just factor that into the I don't know,
That's right.
factor that into the
Yeah, yeah,
model,
that's
that's
right.
part of the
It's
marginal
the same
cost."
thing. It's the
Like,
same thing.
what's your
Yeah,
yeah, where is the state of economics now
right,
on this age-old debate? Like, how do you factor in this type of behavior?
right.
And how do you
Well,
consider it?
I could
Yeah.
start with the model, for example, and sort of work from there to the more general question. So the model itself, again, I mean, I think it's not difficult to take the same model and to throw in risk preferences. And then
Right.
you get different results, and you get hyper litigious cases where someone who's risk prone and would want to carry things into the appellate courts, even when the prospects, even when it's pessimistic, even when the person in when a rational person would be pessimistic, they'd want to carry things. That's something that can be done in the model, and it would generate
Right.
different results. And now let's go to the broader question: what about the behavioral literature? What does that imply? Well, one implication of that is that it's hard to sort out, when if someone says, "Well, this behavioral study shows that people aren't rational." Well, it's hard to sort that out from the statement that this behavioral study shows that some rational people are risk prone. Now
Right.
I
Right.
guess there's a more fundamental question. You could say, "Well, how could you be rational and risk prone at the same time?" Well, that's a good question, but I'm just saying rational is that you have a consistent approach, you have
Mm.
valuations of things that you stick to, and, for you, for one person, maybe a silver dollar is just a dollar, and for you, a silver dollar is worth, $1,000,000 because you get some sentimental attachment you put on it,
Right.
and that doesn't mean you're not rational because you are making
Right.
rational decisions when you decide you wanna go into court over that silver dollar, and spend 5,000 in litigation over that. Can't call that irrational.
Right.
If that's the case, if you're making consistent decisions, but you have a different valuation system because you're risk averse or you're risk prone, I'm not gonna call that irrational. I'm just gonna say that's rational conduct, but with some risk preferences. And that's different. Now, if you said irrational, to me, irrational would mean, well, you're really not making consistent decisions that I can't.
Yeah, I like the way you said that, that it's about the consistency,
Right,
right? That
right,
it's not that you're deciding differently than some other person would. You just have a different way of calculating your utility, if you will, or your benefit from the outcome. And, that's built into the models. That makes perfect sense to me. That kind of explains a lot of, loss aversion, risk aversion, things like that people may factor into their decision as to whether or not to
yeah, and so the
litigate.
more fundamental point is, that's a question that to me sits behind a lot of the behavioral literature. Well, are
Right.
you showing that people aren't rational? I'm not sure you're showing that.
What about the role of Yeah, I mentioned I spoke with another law and economics professor last week, and he talked a little bit about the role of intermediate systems where there's an intermediate court versus where there's just one appellate court.
Right.
And I wonder if that is anything that these appellants might consider, right? If they go up one level, are they now like factoring in, well, if I win here, it may not be final, and then I've got to deal with the headache. Or even in this scenario, you win when you're appealing something, you're appealing specific issues typically of law that then get sent back to the trial court. So now are you like evaluating 2 probabilities, like the probability I win on appeal and then the probability, and even if it gets sent back to the trial court, it could be sent back for a specific issue, like on damages,
Right.
or it could be sent back for a full new trial, and who
Yeah.
knows, right?
Right.
Who knows? How can you predict?
Right. Yeah. So in the my paper, we're just looking at this stage where you've done your trial court and you're asking at this stage, do we appeal?
Right,
Do we settle? And looking at the incentive conditions, you could go a step back further and say, suppose I'm filing in the first case, and now suppose I take into account my predictions about the appellate process when I'm filing in day one. Now that's a different model. Someone could do that. I mean, I could do it myself, but now I've written this paper. It's an open invitation for anyone to do that model if they want to. A two-stage model where you're litigating in both courts and you're now it would be sort of this, backward thinking process where you think, okay, I know what's going to happen in the appellate court. Now let me think back about my incentives at the trial court, knowing what's going to happen in the appellate
right,
court. And then you could, if you want to, layer 3 levels of that. You could say, okay, suppose I'm going to be in the Supreme Court too. So
right,
maybe the trial court, I'm going to be the trial court, I'm going to be the appellate court, and I'm going to be in the Supreme Court. And let's say
right,
I can predict what's going to happen in the Supreme Court, then I'm going to step back to think what happens in the appellate court and my incentive conditional on what I think will happen in the Supreme Court. And then my incentive to go to trial court knowing what's going to happen 2
I know,
stages
it's
down.
almost like a flow chart,
Right.
like those decision trees. You've got like if this happens, then this, then
Right.
this. I mean, it's almost like the real world is too complex,
Right.
right?
Yes. So someone could do that. So it could have a
Yeah.
3-stage model of litigation.
Right.
I think it would just take the model that we set out and just
Right, it would just expand
substantiate.
upon
That's right.
it. It would
That's right.
just say, like, "This is step 2," then
Right.
you've gotta build in the same probability analysis on step 3 and factor that in.
Right.
And,
For
your
most
reference.
real life people, I think the trial court is all they wanna do, so they're not thinking about 2
Right.
stages of litigation, but I suppose there's certain parties that are definitely thinking about 2 stages of litigation when they go into the trial court.
Yeah, in Florida, for appeals, a lot of the appeals are interlocutory appeals too, so it's not like the case has gotten all the way to a trial and
Right,
then someone's deciding a one-shot appeal, like
right,
black and
right,
white.
right,
It's,
that's right.
okay, this court ruled on this jurisdictional issue. I'm gonna appeal that while continuing the main, litigation. So it's
Right,
like that is a different model, I think, than this, right? Because that's like assessing, okay, if I win on this issue, what's
right,
the benefit to me in the overall litigation and what's
that's
the
right,
expected outcome of
that's
that?
right.
But you're not that's not the subject of this. This is more a
That
situation where
yeah,
it's like.
that's not the subject of this, but we do have discussion
Right.
in the model about, what happens when there are motions during the
Right.
appellate process and those get resolved. How does that change your incentive to appeal, when you can predict this? To some extent, that's also what you're talking about when you said that you had this process in Florida with a lot of interlocutory appeals.
Mhm.
You would be thinking about those, how those will be resolved, and that would affect your incentive. That would affect your incentives at the start, knowing that
Right.
you'll be able to appeal some decisions while you're still in the trial court.
Your references to the old Steve Chevelle articles got me breaking out my old law and economics books. I took his law and economics class. It was not a very popular one, but it was most popular to me. But he talks a lot about the socially optimal level of litigation. I mean, I guess that's not really what the subject of your paper is, but could it be like built into a socially optimal model for appeals? Or has that research already been done, you know?
No, not that. I would say on appeals, I don't think anyone's done that. Well, Chevelle has looked at a different question, which is the function of appellate courts as correctors of error
Right.
in the trial courts. But question of what's the socially optimal level of
This is that litigation, that's on the appellate side of things, he's researched, but I'm talking about, like, at the original litigation when you're deciding to litigate, do the private incentives to litigate produce the
socially optimal.
optimal
Right,
level of
I'm
litigation
familiar. I'm
overall?
familiar with that
Yeah.
paper.
No, sorry,
Like,
sorry, but yeah,
it's a very,
I
very
thought
short, very short paper, which is actually makes a pretty fundamental point, which is pretty interesting. I've written some stuff that's related to that paper too, and so yeah, you could say that the private, the Chevel's point was that the private and the social incentive to litigate, those two incentives diverge, and so you'll get litigation that's not socially desirable. Now, of course, it turns out that if parties can waive their litigation rights, so settlement is something that occurs, once the parties decide to go to court. It's often modeled as something that happens after the case is started, after someone is filed, then they entered into settlement negotiations. They could have, the settlement could happen before trial, but you could have a waiver where no accident has happened, no event has occurred that would give rise to litigation, but a potential plaintiff says, "I'm going to waive my legal rights to a
right.
potential defendant." And it turns out that if you allow for those waivers to occur and you assume that the parties are informed, they know everything, then all of the cases of inefficient litigation will be the waiver cases. In that case, the social and the private incentive to litigate will be the same, because that's kind of an important point, I think, that would you allow people to waive their rights to litigate, which, of course, once you mention waivers, that becomes a controversial question, and there's some people who would, run out of the room as soon as you mention waivers. But, if you look at it objectively and say, okay, let's suppose, there are people who think, I'd rather have the money now than to have the possibility of suing someone. If you allow for those decisions to be made and they make them, rationally, and they're fully informed, or as well as possible, then this incentive divergence that Chevelle showed, that no longer holds. And so you could say the same thing is probably true at the appellate level, that I'm sure at the appellate level, the social and the private incentive to litigate diverge also. But
Mhm.
there's probably, there's certainly a possibility for people to waive their rights to appeal, to say, oh, I'm
Mm.
not going to appeal no matter what. The settlements that operate to some extent to that effect too. But that's an interesting question, because when in a simple one-stage model where people are just going to trial court, that's all, there's no appellate court,
Right.
then it's very easy to show that if you have waivers, then this divergence between social and private incentives to sue, that divergence disappears. Now, what happens if you have two stages of the model? That's, to me, I guess that is an interesting question, because it's not clear to me what the answer should be. But I assume the result there should be the same, that waivers would lead to the elimination of suboptimal litigation. And the basic reason for that is the Coase theorem, that says that if parties can enter into bargains, that inefficiencies should all be bargained out of the system.
Interesting. I have to do my homework on that.
Okay.
Fascinating. Speaking of homework, just a little diversion.
Yeah.
What is how would you say students take your classes these days? I mean, I kind of joked about law and economics at Harvard not being the most popular at the time that I went, but is it a popular field of study, or is it, what do you get a lot of haters, a lot of hecklers in your classes, or are they all on board? I mean,
Well,
what is it
that's
like
an
being a
interesting
student?
question. I think in the law schools, law and economics is still strong as a research area. There's still a lot of people who do it, who do law and economics, and it's seeped in as a set of tools that I think a lot of law professors use, even the ones you know who are somewhat distant or even reject law and economics, still use the
Right.
arguments. So in that sense, law and economics has been a success, though, part of its success has caused a backlash. And so there's some universities, there's some law schools where it seems that, there's a strong antipathy toward law and economics. So, for example,
Right.
there's a new movement called the law and political economy movement, and
Hmm.
it's gotten very popular both at Yale Law School and at Harvard Law School. And Yeah, I think their basic tenet is that we'd like to do away with law and economics.
Right, right,
Uh,
right.
so
But I
while
mean, it's
adopting
but
some of the
right.
methods of the field, so law and economics is in good shape as a research method. It is, and to me, it's certainly a very important methodology in the law schools. One of the most important, and I, in fact, in my biased perspective, I would say is the most important
Right.
methodology. But certainly, it's an important method. I think anyone who's honest in the law school would say it's certainly an important and valuable methodology, but it's kind of sort of in retreat at some of the elite law schools at this stage, largely because
Mm.
I think of a reaction in a sense that, you know, we're uncomfortable with this. Part of it may be that, part of it may be a view that economics has, in some cases, you know, generates questions that are uncomfortable to answer in the law school setting, sometimes
Mm,
leads you down the road to ask questions that seem uncomfortable, sometimes leads to answers that seem uncomfortable to law students. So that's led to some backlash and some
yeah.
distancing from law and economics. So I think to some extent, law and economics is a victim of its own success.
It's interesting to hear that feedback, how it currently stands in the elite circles, in which you know, you teach and where you are. I mean, yeah, it to me, I mean, it seems like just like math or science or any other inquiry where you start with, you know, fundamental principles and build up. I mean, it's not intending to divert people a certain way or not. It's a framework for thinking analytically, and we can debate about what inputs, what outputs, but it's just like the law itself is just a framework. This is a framework, and I think it's so disregarded so quickly by a lot of people. I don't know why, because it was never really the people that I've met who are intellectually honest will acknowledge all the things that other people are, you know, the people that hate law and economics are saying. They're just saying, yes, that appears to be in the evidence. Let's build it in, you know, like
Right.
we were talking about
Right.
earlier. Anyway,
Right. Yeah, yeah, yeah,
back to the
that's a big
article.
what you've just asked is a big question, which I've sometimes
Yeah,
struggled to answer myself because I would have thought, to me it's a powerful methodology, and I would have thought it would be, maybe enormously popular in most elite law schools now, but I would say no, that's not the case.
all right, well, back to the article. Another thing that the litigators I spoke to mentioned was this concept of backfire. You know, you go to appeal a case and you may think you've got this option in the bag to go back to your trial court judgment, but there's a risk that the appellate court, you know, not only says no to your appeal, but reverses your original win, or says, you know, I on my own, without even any party moving, making this argument, I on my own decide there was no subject matter
Yeah.
jurisdiction at
Oh
the
yeah.
trial court level,
Right.
and
Right.
bye bye.
Yeah, that's right.
So like, how does that affect the model? I mean,
Yeah.
can we really factor it in as like a purely,
That could be factored
you know,
into the model. I mean, I don't. I mean, that's an interesting question. Let's suppose the appellate court says, "Well, actually, the trial court didn't have jurisdiction, so you lose." Yeah,
right,
that trial
right,
court judgment you thought you had, no, you don't have that anymore.
right,
That's I I maybe it wouldn't be a big deal to factor that in because, that seems to be something that would motivate a defendant to appeal right away. If the plaintiff gets a judgment and, favorable judgment, and the defendant's argument is, well, the trial court didn't have jurisdiction in the first place. That's information that the defendant has that's valuable,
right,
and he wants to bring it to the appellate court. So I could say one view of that is that the model does take that into account already.
right.
I suppose the
You would just yeah, you could do, I guess, like, you would just say that your DA would have to factor in, or your PA
P right, right.
multiplied by
It's the
DA would
the
have to
P's that would differ. Yeah,
it would be like yeah, it would be like a subset of that. You'd
right.
have to, like, build into that variable that, well, there's always the risk that we just totally blow it and lose, you know, but then
Yeah,
yeah, and then
there's
you
the
need to
risk
keep
that
your
that DT that you have will disappear quickly, will disappear faster than you thought it would disappear. I think
right,
that's a pretty I mean, I think that's a not a big deal to change that.
simple adjustment, yeah. Okay. There, a couple other nuances, but I'm sure the answer kind of is similar for these other things like attorneys' fees provisions and how that incentivizes, people or not to
Right.
appeal or to litigate in the first
Yeah.
place. We talked about interlocutory
Yeah,
appeals.
attorneys feels that the model could easily be modified
Easily
just
factor that
because
in.
that would just change the way that the litigation costs are allocated. That's easy.
Right.
It's a mainstay in the law and economics literature to examine, what happens to incentives to litigate if we change the allocation of litigation costs. For example,
Right.
we make the plaintiff pay the defendant's costs or the defendant play. What
Right.
does that do to the incentive to litigate? And I don't do that. We don't do that in this paper, but we could easily do that. That's another thing,
Right.
or someone else could come along and do it if they want to.
Right. Yeah, same with I mean, there's so many different things that people have considered at the trial court level that could just be built into this one. One other thing, just on the practical level, that both people I spoke with mentioned was just the role of bad attorneys, like attorneys that egg their clients on to appeal when they shouldn't, or attorneys that are so prideful, and ashamed and embarrassed they lost at the trial court level that they convinced their client to appeal. I mean, that kind of goes into the bucket
Right.
of, well, you also have irrational clients,
That's
right?
right.
This is
That's right.
nothing
Yeah.
new under the sun. It's just a form of like joint irrationality, I
Right.
guess, if you will.
Right,
Right.
right. In the model, we have the predictions, the beliefs, we're sort of assuming a merged attorney and client, they're the same person. But if we change it so there's an attorney with beliefs and a client that has beliefs and they are different, well, that becomes a more complicated model. And I mean, I think that can be, built into the model. But it's certainly true that in the real world you have lawyers who may want to appeal or may not want to appeal because they have incentives that differ from what's best for their clients. And that incentive divergence, that's always there, or always potentially there. To some extent, legal ethics rules are supposed to govern these incentive divergences, but they probably don't govern them perfectly. So I'm sure there are cases, in the real world where attorneys push for appeals when it's not a good idea, when rationally they shouldn't, or where they don't appeal even though rationally they should. And that incentive divergence, that agency cost factor can be put into the model. Again, I would say to someone, sure, go ahead, change the model and put that factor in there because others
Right.
have modeled this agency cost issue before at the trial court level. And I'm sure
Right.
it can be put into an analysis of the appellate court appeal decisions as well.
Interesting. So where would you like to go? Where would you like to see this research extended? Like where would you like to see the next researcher take your paper and add on to it? What do you think would be the a good
Well,
follow-up?
the truth is, I'm happy to see someone do whatever they want to with it because I look at the model as a basic skeletal framework anyone can do. When I talked about the paper at last year's American Law and Economics Association meetings, one of the people who was there came up to me and said, what if you put in, informational asymmetry into this model? One party knows more
Mm,
and maybe this person is working on it already. I mean, that's something that obviously someone can do. Someone can say, well, let's suppose you have an uninformed plaintiff and a relatively informed defendant. What happens in those cases? So there are all sorts of things. I mentioned risk aversion already. How does risk aversion affect these incentives? I've been thinking about empirical applications. In fact, Sanghoon and I are working on an empirical paper. In fact, it was the
mm,
empirical paper that we were working on at first that led us
right.
to write this paper. So now we're back to the empirical paper that uses the same model to try to estimate, some equations, probability equations for the outcomes at the appellate level in a sample. So I can see that there might be the different ways of modeling it, risk aversion, informational asymmetry, or as you mentioned already, different ways of allocating litigation costs,
Right.
agency costs, these divisions between plaintiffs and lawyers. There are all sorts of issues that someone can just take and examine within the model itself. And right
Right.
now, we're working on this empirical application where we have some data. We're trying to use the model to estimate, some, you different some probability equations for appellate court outcomes using the model. So,
Interesting.
but
When is that coming? When would that be? When do you think that's going to be out?
that paper, it's probably 6 months away, something like that. I'll see.
Very
And it's in
cool.
the referee process right now.
Very cool. I'm excited for that one.
Oh, thank you.
All right. Well, I think that kind of concludes our discussion of the article. If you have time for one more question, I'm
Sure.
curious about something separately. Okay. This is totally not related to your article.
Okay.
It was something that I had spoken with, uh, again, my prior guest about. We were talking about the law and economics field generally and the Manny program on economics back in the 80s and how, antitrust was like this footnote or like this weird carve out to me. Again, I'm no longer an academic or studying this for my
Yeah.
full-time day job, but I thought that was weird. Can you explain to me, I guess, where meaning like the law and economics movement generally back then was saying, judges should like think about economics and incentives when they're making their decisions and
Right.
they trained people on this. But then when it came to antitrust and antitrust regulation, like the movement, the people associated with the movement were like antitrust regulation, meaning they thought I don't know, monopolies were okay. Like, I guess how does the current thinking, how does the current scholarly research on this? What's the approach to antitrust regulation from if you took a survey of
Oh,
law and economics people, what is it?
that's hard to say. And there are a couple of things that you mentioned in your question. You mentioned the Manny program. And so
Yeah.
I thought at first this is what you were going to ask about. But on antitrust in general, I think it's good for judges to be aware of a lot of basic points about the economics of antitrust. I think it's good for judges to be aware of the economic implications of antitrust doctrine, the extent to which those doctrines can be justified on economic grounds, the likely effects those doctrines are going to have, at least the foreseeable, based on the rules themselves, the foreseeable incentive
Mhm.
effects. I think those are good things for judges to think about. In terms of the field itself, I think what antitrust scholars are saying, I think antitrust scholars who do law and economics, I think are all over the map. I think some are
Yeah.
very pro antitrust enforcement. Some are more hesitant about antitrust enforcement. I would say the one good thing about antitrust law, as far as the people who are doing economics in the area look at it, is I would say that the one good thing is that there is a common understanding or framework that they all agree on. So I might disagree strongly with the position that, say, Carl Shapiro takes on something, but we agree it's economics. There's no fight about the basic terms. And to me, that's really kind of important. That's something you don't see in all areas of law. And the people in constitutional law, they disagree about things, and there's no agreement about what even the words, the meaning of the words they're talking about. That's almost an unbridgeable kind of disagreement in many areas of the law. But
Got it.
you know,
So there's
when it
there's
comes,
no so yeah. So there's maybe my like very, very elementary knowledge of this or reading of one quip in one paper, it doesn't give it justice, the diversity of viewpoints on this topic. And it still goes back to the frameworks that you can all agree on. It's
that's right.
just, yeah, I got it.
Yeah,
That gives me some peace that we're not
yeah. I'm
I
not.
was like kind of surprised by that. Like the thought that people who subscribe to law and economics like somehow are antitrust regulation all the time. I
Oh,
thought
that's
that
not
was
true.
weird.
No, I mean,
That's not
the
true.
views are all over the place.
Yeah.
Now, I think judges can benefit from you know, thinking about economics in this area,
Sure.
no matter what their preferences are, and no matter what their views are, and so the Manny program, there was a recent study that showed that there are certain effects of the Manny program just published maybe a couple of months ago.
Yeah, that's the guy I interviewed,
Oh,
the guy who
is it Dan
wrote
Chin?
that well, I no, I interviewed Elliot Ash,
Okay,
his
all right,
co-author.
yeah, that
So,
paper.
yeah.
I'm familiar with that paper.
Yeah, yeah, it
Um,
was fascinating. It
Yeah,
was
right,
like,
right.
wow.
So I think it's still, and I think the results of the paper, it's not clear how they should be interpreted. Because
Right.
you can take a positive or a negative interpretation of the results of their paper.
Right.
I think the Manning program became controversial at one point because people thought they're trying to brainwash these judges. And I think one of the offshoots, one of the effects of that is the American Bar Association has been offering an antitrust economics education course for a few years now. I've taught their course a few times. They've made a deliberate effort, from what I can see, to have people have different viewpoints on it, who are sort of on one side of the scale versus another. Yeah, I think it's a pretty good program. I think you lose something sometimes when you decide I'm going to have different viewpoints of related in this course, because sometimes it loses some consistency and coherency, and you get some people coming in just sort of trying to persuade the judges of the rightness of their
Right.
view. I think you
Right.
do lose
Right.
something. The ABA model does lose something, but in the end, I think still judges benefit from hearing that kind of material.
Sure. Yeah. I mean, especially in antitrust. Antitrust and tax law, I thought were the two most, at least for law school,
Right.
if I think what would an econ nerd love to study? Antitrust or tax, right? I mean, it's just both structuring incentives and behavior and just very clear
Right.
analytical frameworks, if you will.
Right.
All right. Well, this has been really great. Really appreciate your time. Thank you so much for speaking with me. I look forward to staying in touch and
Yes.
seeing that follow on research paper.
Okay, great. And thanks for
All
this is a
right.
lot of fun, and thanks very much
Yeah. Yeah.
having
All right.
me
Bye,
on.
Professor.
Okay, bye. Thank you.
Yep. Bye bye.
Okay.